Hey, everybody. I'm Greg Siskind. I'm joined by Aaron Hall and Jesse Bless, and we're going to give you an update this week for what's going on with IMMpact Litigation and maybe if there's anything else in immigration law that comes to our minds. We do not, again, this week have Chuck Cook. We did talk to Chuck this morning, who we said last week was under the weather, and he had a medical episode that he'll be out for a couple weeks, probably rejoining us on October 1st, I think is what he told us his target date was. So we wish Chuck well, quick healing, and fortunately, we are able to step in and fill his hosting shoes for a couple weeks, but we definitely will look forward to him rejoining us. I'm also doing this from my StreamYard account, so I don't have all of Chuck's great banners on there, but I do have the ability to show your comments, and we'll take questions. Which last week when we did this, we didn't take questions from you guys because it was a brief. It was not on the right day, and it was an abbreviated format, but we should be able to do that today. So why don't we go ahead and get started with the I-601A case, the Guevara case. Aaron, where are we on that case? What's next incoming? And we did have some good news finally from another court on that. Maybe you can talk a little bit about that.
Sure. I think it was last week, right before we did the live, is when we got the case out of Colorado, the Granados case, where the judge denied a motion to dismiss on the 601A case. So we reviewed that, actually got with counsel on that case, and have been going back and forth between co-counsel on our case, on the 601A case, and are preparing a notice of supplemental authority. That should be filed this week. And we also think that we're going to file the same notice on the 601 case because it's not the same application. The jurisdictional arguments are very, very similar. So we will be preparing those notices and filing them, like I said, I anticipate this week to the courts.
Right. And it does tend to show what the difference is. I mean, that it's not just our judge and our case and how good a job we do, but we're affected by what's going on in other cases filed in other courts around the country. So for the last couple of months, we've had a few cases that haven't been so wonderful as far as those decisions go. The judge should be able to make an independent decision here, but obviously all judges are influenced by what's going on in the other courts around them on similar issues. So, Jesse, I don't know if you wanted to say anything about that case, and what you think.
Yeah, it was an interesting case. I mean, I don't need to really get into the reasoning, which is slightly weird. The way he described how if it was a total shutdown, that would be okay, but because it's not okay. But I mean, I think for purposes of our case in Guevara, the judge isn't going to change his mind because this one district court in Colorado decided to deny a motion to dismiss. So if the comment in the chat that, is this going to change things for our case? No, it's not. And the reason it's not is because the Ninth Circuit Court of Appeals, which is where we sit and has control over cases in Washington, they're going to make a decision, and the judge wants to wait for that decision. And that's okay. I mean, honestly, I think what people need to understand, we've actually accelerated. It doesn't feel this way, but we've accelerated the pace where you're going to get to a conclusion. Because if that Ninth Circuit case comes down and reverses the district court's decision, I think, that is obviously going to dictate the result in our case and probably the outcome, meaning they're going to start working cases really quick. So I don't want to say the best thing that ever could have happened is a case that goes to the Ninth Circuit Court of Appeals, but if you're worried about the timeline to a final decision and the government wasn't going to settle, it's not such a bad thing that we're here where we are right now. It doesn't feel that way. I understand that, but it's
a big risk for the government too.
Totally.
Yeah, I mean, if the case does not go the way that they're hoping, it's going to make their lives a lot more difficult, not just in our case, but in a lot of cases coming after us.
And you know, it's crazy too, because there's going to be a lot of resources. You know, they already have a great attorney in the Fourth Circuit case, Paul Hughes, who's going to be making some, you know, I've seen the brief. It's all unbelievably, it's brilliant, of course. And what the government's position, which in my view, having argued in a lot of appellate courts, when you tell them, and I know, I mean, people are going to say, well, what about Patel? Patel is different. But when you tell Article 3 courts that there is nothing you could do if the government takes money and decides never to process your case, I think it's going to just, the statute doesn't read that way. It flies in the face of like the Administrative Procedure Act and, you know, a lot of law out there. So it's going to be interesting to see what happens. I'm optimistic, to be honest. I mean, I really do. I think the judges are out of whack.
All right. Well, we obviously a lot of people pulling for that point of view. So I did want to let people know. You know, I keep an eye on. I usually check almost every day what's happening with our plaintiffs' cases. I can tell you that we are still sitting at the same number of approvals now for the better part of the last 10 days. We also haven't seen the last case transfer we received was on August 21st, and that was the last action on any of the cases that we have. So I don't have any news to report there, but I would like to keep you guys up to date. Anything else that we want to mention with respect to the 601A case?
I'm aware of the district court in Massachusetts has actually set a case for argument which on a motion to dismiss, which is, I guess, not so unique, but somewhat unique, I guess. So that's going to be in October. So I don't know. That's about it.
Okay. All right. Aaron, what about the 601 case? Is there any news to report there?
It's the same news. That's where I also want to submit a notice of supplemental authority on that case. Just explaining that these jurisdictional arguments are related to the ones in the 601A cases, and that it militates in favor of finding that there is jurisdiction for our claims.
Okay. All right. So we have plaintiffs that are in the Go and Gomez cases that are watching today. And this is the one case where Jesse, we're allied with Jesse, but not technically in the same case. He was a Gomez lawyer, and we were Aaron and I were on the Go team, but we are all in the same boat as far as this goes. So, and the appeal to the DC Circuit was for all the cases. So. Once again, we have no news to report. I wish I mean, we're just sitting, but I don't know if you guys have any thoughts as we approach the 1-year anniversary since our arguments.
Well, I mean, here's what you know, the DC Circuit issued a decision the other day in a pretty important case, non-immigration related, this case called Grayscale that has to do with Bitcoin. And it was an APA case though. Mm-hmm. If I'm reading the tea leaves, because they said, you know, the point was they had denied a request for someone to create an ETF or a product for Bitcoin. And they said, well, you rejected this one and you kind of approved these other ones. And the APA requires you to treat same cases alike. And the DC Circuit, where Srinivasan was on the panel, affirmed that principle. And you know, I think you can draw some parallels to the Go and Gomez cases in some ways. You know, it's a strong kind of defense of the APA and what is arbitrary and capricious, and that's certainly present in our cases. But you know, in terms of a timeline, you know, again, no. You know, I know. Listen, we're at the annual point too. I mean, everybody's so anxious over DV right now. And about, you know, the number that's left. And there's probably people who are listening to this. And, you know, I know Algeria just said that they don't have any more. They've run out of their own capacity to handle any more diversity visas. So obviously it's an anxious period. I mean, I think what I beat the dead horse here with, let's say we win. Let's say the decision comes out tomorrow. Okay. Your next email is going to be, when do I get my visa? And I need you to understand that, number one, the decision has to be favorable. Number two, there's a long road to go, because from the time if it's favorable and they say, yes, these visas need to be issued, it's about the manner, meaning how are we going to issue, because there's more people who want visas than are available. And then it's going to be about when and timing. So there's work to be done if we get a decision, but I would expect it. I mean, honestly, I expected it 5 months ago, so I'm way out of line. I can't tell you.
Yeah, we were issuing predictions, that we were going to get a decision probably in the first quarter of the year, and we thought that was actually being conservative. It is. We definitely know that that you guys are anxious on there. We are as well, and obviously, the moment that we have any news, we will be posting it to everybody.
Related, but not with those cases. I'm getting the email here and there from DV 2022 people. I'm sorry, 2023 people at this point, saying they have a month left. Is there anything that we can do to get them through? And frankly, without having an active case this year, I'm not following it like I have in past years. I'm following it more passively. But my understanding, and maybe Jesse can correct me if I'm wrong, my understanding is that they're on pace to hit or exceed the statutory limit again. And if that's the case, it's going to be very, very hard, if not impossible, to get your case done through federal litigation. So that's my opinion, but like I said, I haven't been following it as closely as I have in prior.
Yeah, I had, I still get pinged all the time, and I've told people now, I said, listen, every applicant feels like, in litigation, and they've seen the YouTubes, and I tell them this, and this is the expectations that they have. A lot of our clients all the time, they treat lawyers like restaurants. And I used that analogy today. And I said, listen, when I go to a restaurant, I pay for food, I get it. When you pay a lawyer on a DV case or any case, on a delay case, you may not get the food. And and for DV in particular, we've learned the hard way it doesn't even matter where in the world they're issuing them. And it's unfortunate that they don't issue them the way they should, because a lot of African countries and a lot of Middle East countries and a lot of other particular countries get screwed. But they're going to be able to go to a court and say, look at all the great work we're doing. We're over the cap.
Yeah. And the only thing I'll say, I guess, in the Department of State's defense is during this last 30 days, it's very tricky for them, because they have, they have a certain limit, obviously, that they have to adjudicate. They have country limits and regional limits. They also have requests coming from consulates as well as USCIS, because some people are in the United States and applying for adjustment of status. And there's I don't know if it's one person or a team of people that are actually, like, on a daily basis keeping tabs on the numbers, and are probably telling consulates, get everything as long as you can, and then we'll let you know when, which consulates are getting which numbers on there. And it may be that the consulate is trying to get you approved, but they're waiting on approval from DC, and DC is right now, counting every one of them and trying to make sure that they are not approving more than they're supposed to, but not approving less either. Their goal is to get precisely the right number approved, and for, within the right allocations, and not leave any left over in the end when they have that capability. Now, obviously, it was a different story a couple of years ago, but I think for this year, if you've done everything is sitting at the consulate where it's supposed to, and they're just sitting on it at this point, that could be what's going on.
Yeah.
So, not to say that you shouldn't be diligent in continuing to press the consulate and making sure things are moving so you don't get forgotten, but it's also possible that they, the consulates did the work on this. They would like these cases to get adjudicated. They, as opposed to taking these cases all the way through and then seeing them actually go by the wayside. Hopefully that's the way they view things, and we'll see. Okay, so that's go. I know that's not a super satisfactory answer for people that want to know when they're getting a decision on that, but that's the best we're going to be able to do for right now. Let's talk about Astakov, which is the sequel to Shumalina, our Ukraine case. There was some news in the last couple of days on that case, and Jesse, I don't know if you want to talk a little bit about what's where we are in that case. There are lots of issues that are going on that have nothing to do with the substance of whether anybody's actually entitled to a refund. There are procedural issues that are at stake in this case. So why don't you talk about that?
Well, I will. It's funny because I didn't even told you two this, but I did get a call actually on this case from our friends in the government, and it was random. It was for another case, and it bled over to this one, and they knew that I was, we had done Shumalina and now this case on, and I saw. And the response I really got was, and speaking to the procedural kind of games, we just don't want this case in DC, and we want it to go to the Federal Court of Claims. We haven't even thought about how we would pay the money back to the people essentially who had to pay for fees. And yes, we're not, and it goes right to what I'm talking about earlier today with the DC Circuit saying that you have to treat like cases alike, right? They took money from some. They kept it in others, and they had a real problem on the merits. But they're not even focused there. Their focus is on kicking the case to another court.
Right, and there's a big reason why they will likely lose in either court, I think. But there's a good reason if you're the government why you want it in the other court. Which when are you explaining how that?
Yeah, so. It's actually something I learned, which is in the Federal Court of Claims, if you have a class action, you have to go and find the people, and they have to essentially elect to participate. So, and in others, in the court we're in now, in the DC District of Columbia, they actually have to opt out. So they're in until they tell you they're out. And in the Federal Court of Claims, they're out until they tell you that they're in. And so it makes a big difference. And it puts a lot of the burden on us to, track down. I have to believe though that the merits are so bad in this case for the government that once we get through the games, that someone's going to have a moment of clarity and stop treating people this way. I mean, that's just, again, I'm kind of hopeful about that, but it's really about what. I'm trying. I know are we on YouTube or something, so I can't swear. It's really about who wants to hold the bag at the Department of Justice when we actually have to go before a judge and tell them what exactly is going on. It literally is like that. That's what's happening.
And that's one of the developments right in the last 24 hours, I guess, which is that we are trying to get oral arguments on this issue about about moving courts, and we'll find out soon, hopefully, whether that's going to happen. But that being said, the government, I think, likes this case not being in the news, and they probably would not want to make public arguments on this case either. One thing I will say is that I think, if it ends up in the Court of Claims and we have to, and it's opt-in, one question I have is whether we could still potentially force the government to at least have to give us the contact information for everybody that has these applications pending, as opposed to making us go out and have to find them for ourselves. And that's something, is that if it comes down to that, then obviously it's not as easy to track everybody down, but it would still make it a lot easier for us to be able to get people's money returned. That's something I presume will be, a question if we end up in the Court of Claims.
Yeah, either they didn't keep track of it, and that's a problem that'll force them to settle, or they have it and they're gonna. I would have to believe they're not gonna be able to hide behind it. I mean,
Yeah. I mean, one of the arguments that we made is that, obviously our plaintiffs in Shumalina and our plaintiffs here are not afraid of the government. They are, they stepped forward and they were happy to represent their compatriots in litigating against the government. But what the government's counting on is that there are thousands of people who are afraid of actually confronting the government and asking for a refund. And that's something that's an argument we raised as well, which is that, refugees by the nature of their situation are not usually all too excited about suing the government that let them come into the country and seek refuge. And I think, cynically, I think our government in this case is counting on that concern, and that's one of the reasons why they want an opt-in case, because they do think that a lot of people that got Uniting for Ukraine benefits are going to be afraid to sue the government, and that's pretty shameful in my opinion. That's the if that's what's going on. I hope it's not, but that bothers me a lot. If that's sort of the reason why they're counting on getting this into the court of claims.
I think we just have, again, it's like the dawn of like football season, and you have teams every year who don't know how the hell to run a business. And that's really what our immigration system is. We cut the wrong players. We focus on the wrong positions. We have no idea, once we get the 53 in the room, how to actually put 11 on the field. We have no idea how to actually have a system. We like to point things like it's like the Cowboys and Redskins, right? They've been so inept for years, where they'll just go out, they'll steal free agents and make headlines in August, and then in October they're like 3-6, and they're like, oh, we suck. And it's like, yeah, you suck. You know why? Because you don't actually know how to manage the system. And what we have Joe, who has come in with some great ideas. He had a deep bench. He had an 0-15 team, and you know what he did? He's like, he focused on the line. That's it. He has no, and that was the border. And then a couple guys got hurt, and we got bad cases. But so the sole focus of this administration really has been on that border, and we've done a hell of a job screwing Afghans and Ukrainians who actually really needed immediate relief. And then we brought them here quickly, and basically, didn't really give them the benefits they needed. And then this is the best, because I'll call the DOJ the trainers. Then we got trainers who can't keep people freaking healthy, right? And they're out there taping up ankles and trying to and they're screwing it.
Wrong analogy.
Well, they're trying to train. They're trying to show everyone that they're keeping everyone healthy. But what's happening is everybody's still sick. And they haven't actually done a good job, in my view, of pushing the AG, the Attorney General, and the Solicitor General to stop litigating certain cases and to direct their attention at defending some of these crazy people who want to tell the federal government that they can't help people at the border. Yeah. And again, how many good people, lawyers at the Department of Justice, are fighting our cases for DVs and refugees and not focusing on the DeSantises and the Abbotts who are trying to tell them that they can't run their system? It's just insane. It's insane.
I thought that whole analogy was going to be an attack on the Denver Broncos, so I was happy to hear them not.
I don't know if it was also because the Patriots got clobbered by the Titans last week, so maybe.
No. The reality is this. No, you can't pick on Denver. Nor can you pick on Tennessee. They have great professional teams. Those teams, yeah, but here's the thing, right? And this is what happens for the Broncos, and this is what Joe needs to be careful of. Because I think immigration is, going to be a huge, huge issue next year. And there could be a change in the coach. Coach could get fired. And, a lot of promises haven't been kept. Yeah. And, goddamn, with the 601As and other people, I mean.
Speaking of Biden, one thing that is related to our case, although it is not, I guess it shouldn't affect it that much, but the pool of plaintiffs that were eligible for our case were the ones that entered the country after February 22nd, 2022, and are coming before September 30th, 2023. The September 30th date, there are questions about what's going to happen with that population going forward. And one is that because the Biden administration just renewed TPS and moved the dates forward a year, I believe, in that a lot of our plaintiffs will probably switch over to TPS, which is great on there. But there is legislation that is being introduced now, a new supplemental bill that should have that same language in there and extending it out another fiscal year. So that should still be applying. And the reason why that's still relevant for our case is not that people are paying fees now, but we're actually arguing for some other things in that case, including getting a declaration from the judge regarding the applicability of the automatic work authorization to the population, even the population that's coming in now, to continue that, because they have we still haven't gotten real clarity from the government that they misread the statute on that, and they said that they're giving automatic work authorization going forward from last November, but they aren't saying they're doing it because they had to do it. They're doing it because they like Ukrainians, I guess. But the other part of it is that we are trying to deal with this obscure issue in this case that actually has a big impact, which is the Social Security Administration has a role in this. And basically what the government said last November is that Ukrainian parolees are to be treated the same as refugees. Refugees, when they come into the country, they are entitled to automatic work authorization under the regulations. They get 90 days. After 90 days, they either have to present a employment authorization document, which they can almost never get in that 90-day period because the government usually is taking way longer than 90 days, or they have to have an unrestricted Social Security card. And that's the rub. The Social Security Administration issued a memo several months ago. It was actually last November also, basically saying, hey, these Ukrainians can now get Social Security cards because of the supplemental bill and because they did it right around the same time that the Shumalina case went away after the government made that policy change. But they didn't take that last step and say, unlike refugees, they get an unrestricted Social Security card. Refugees don't have any problems with work authorization because it takes them about 30 to 60 days. They'll get an unrestricted Social Security card, and then they don't need that work authorization document from USCIS. But they are not treating Ukrainians the same as refugees that are coming into the country, despite the statute saying you have to treat Ukrainians and give them the same benefits as refugees. We believe, and we haven't been able to find the piece of paper that says this, one of the reasons why we'll need discovery, but we haven't found, we know Social Security Administration is refusing to give unrestricted cards to Ukrainians. What we believe, talking to people that are in the know, is that the reason why is that they are relying on DHS to tell them that they need to treat the Ukrainians like refugees for Social Security card purposes as well, and that they're following DHS's lead. So we want the judge not only to issue refunds, but we also want the judge to order DHS to tell SSA they need to give unrestricted cards to refugees and to Ukrainians so that they're treated the same as refugees under immigration law as far as what documentation is needed for proving work authorization. So it's a complicated issue, but it is an important one, and it's also another reason why we're arguing that we need to stay in the DC district. The government's saying, well, the Court of Claims can make a decision on this as well, but that's not really true on there as far as what they're empowered to do at the Court of Claims. They are focused on finding money issues, not on making decisions on the legality of government policies, and that's what we need the district court to do here as well, in addition to ordering the refunds be issued and people be restored the funds that they paid in. So that's something as well that we're keeping an eye on. Any other comments, gents? Any other cases we want to talk about right now? Chuck usually talks about the EB-5 cases. I don't know if there's any news there. Nope.
No.
So we have questions we can get to. I'm just reading them right now. And I'm trying to look for the ones that are questions.
I just love seeing Britt Simon's face pop up. Just like, I miss that guy. Like, I really do. Like, on my bucket list, I need to go and have lunch in California with him. Like, well, and just like, he's like literally the Charlie Oppenheimer of diversity visas. Like, he's the only one who really knows how.
Right. I would say he knows more about this subject than any person in the country, even though.
And he's lived it. And he's lived it.
Even though the government questions whether he is at all an expert, even though he knows more than anybody in the government, probably, including the people that actually count the numbers.
Well, I deposed the head of the KCC. He knew nothing about it. He's a good, nice guy though, but he knew nothing how it worked.
Yeah. So I guess that he's right, and that I'm guessing that they're not going to have any trouble getting through the numbers. If they did it last year, there's no reason why they're going to. If they don't get to it, it's going to be pretty close. I think as far as where they get to in the end.
No, they're probably going to overshoot.
I guess one question I have is whether if there is a consulate that's playing games and is just not requesting numbers for people that they have, how it would be interesting to know how Washington compensates for that. Whether they know that other consulates have a excess of demand, or they put the word out saying it's like, we're not going to hit it in this region unless we get some more requests on there. So
there was discovery that, I don't know, like Curtis Morrison had obtained. And, this was back in the kind of the dark ages when they were basically 2020, 2021, where they, you did have some brave souls bark at Washington to be like, why aren't you giving us cases? Like, what the hell are you doing? Because I do think there are really good government servants out there, and consular officers and visa chiefs and whatever. I think when the problem that I see from Department of State is either they cannot find people willing to serve in certain areas, and then they just give up, like Accra, or and they just won't do anything about it. They like pretend it doesn't exist, and they're like, oh, we hit 55,000, but like, if you look at some of these countries, and it was Egypt last year where they just made a total turn away from issuing, and then you have great places like Britt was just posting about how Algeria, I think they did about 3,500, and freaking insane. Good for them, but we need to develop a better mousetrap. I mean, honestly, you could throw on your little AI machine and tell me where the hell we need to put diversity visa capacity to kind of even out the process, right? That should not be a hard issue.
Honestly, I mean, it should all be centralized in DC, and they should be doing interviews by video, and it shouldn't be, basically luck of the draw of which consulate you happen to get. Because, they have lots of, it is the 21st century. There are lots of things that they could do that will make this problem not necessarily go away, but be much reduced. Nick asked a question that we seem to get fairly frequently on not just the 601A case, but other cases as well, including the Go case, about requesting. First of all, no, the judge hasn't actually done anything that would be improper yet in this case. I think the frustration people have is that the judge is not issuing decisions at the pace that people would like on there. But what the decisions that he's made so far are not any evidence of mismal or nonfeasance in any kind of way, or anything that we would complain about. And if you have to actually have a basis to request, to put that kind of request in. And then if you did put that in and you were baseless or you lost on it, that's not the greatest relationship to have with the judge in your case. Is where he basically said that judge is incompetent, that judge is biased, that judge has a conflict, wherever it is. So it is. We definitely feel people's frustration that this is dragging out. You can blame our government for that in a large respect, but the judge that's in the case, that's not a realistic option.
Yeah. It's the judge we want if the Ninth Circuit rules in our favor. I mean, that's just the best way I can say,
Yeah. Yeah. I mean, the judge, in a lot of the cases, the judges who are focused on procedure are, when they actually get the substantive arguments in front of them, maybe just fine, or even better than fine. So we don't have any reason to believe that this judge is inclined to issue a bad decision. In our case, the fact that we're having to go through this product, the government may be happy that they're dragging it out, but as Jesse said, they may, at the end of the day, be very regretful about having decided to take the strategy that they're taking.
Right.
Because if they
And I think it's important. So if this judge wanted to be really mean, he could have just granted the government's motion to dismiss like the other courts had done. That did not happen here. He had a fully briefed motion before him telling him from the government, you can't do anything, Judge. You can't do anything. And he said, yeah, I'm not going to actually make a judgment on that. I'm going to keep it as if I do have something I can do about this. And I'm just going to wait a little bit because, his superiors at the Ninth Circuit Court of Appeals are going to actually tell him whether he actually can. And once he's told that he can or can't, obviously things are going to flow from there. So, yeah, he did. Again, you may not like what he did, but honestly, we're in a traffic jam with the Ninth Circuit. So there's
can you talk a little bit about the timing of when of what's going to happen at the Ninth Circuit?
I don't have the schedule before me, but I know it was expedited. And I know that the first round of briefing is coming, I believe, in 30 days. Could be less or a little bit more than that. I'm not exactly sure. But the Ninth Circuit has agreed to hear the case expeditiously. I don't know, again, as we've seen with Go and Gomez, judges don't tend to react to the urgency of when we want things done, but they did expedite the briefing schedule. I know the Fourth Circuit also, I think the briefs actually completed maybe there. That's in, Maryland and Virginia and DC. So we're going to get some rulings, but hopefully we hear something. I don't know when it'll be, but yeah, it's the life of litigation, I suppose. Did we lose Greg? Can you hear me?
Greg bailed on us, huh?
I guess I'm going to take this last question because she's like my favorite person in the world from Irene. Oh, I was going to take on the asylum
for a second.
I don't know if you guys do these kind of asylum-based mandamus cases. I do some. I've never thought of putting them in a class. I don't see why you couldn't, but it's very localized, which is what affirmative asylum usually is by, your local. So let me just explain what that means. So if you file like a mandamus in Los Angeles, most of them will settle if they've been pending, but they give you an interview date like a year away.
Yeah.
In Massachusetts, where I am, I filed a couple and I had the couple had an interview in 2 weeks. So, and in Virginia, if they'll file a motion to dismiss if it's less than a certain period, I think it's 3 years, and if not, but then their interview is like 4 months. So it's really local. So I don't know how a class action would work. Telling them what? Let's see. The government has to do its job and issue a decision within 180 days because that's what the statute,
And Jesse, there's the asylum offices are kind of regional. Like for example, I think ours is in New Orleans for our state on there. So there are a lot of district courts, I guess, that are they doing the decision making as far as strategy based on the asylum region, or are they just doing it based on the court's jurisdiction or the state specific?
Yeah, I haven't done a ton of asylum mandamus because usually it's hard to get people confident, like, hey, I can get you what you want. Are you sure you want this interview? Right? You could be putting in removal proceedings, if it doesn't go successful. But the ones, obviously, Massachusetts is easy. That's only one asylum office.
Right.
I think Eastern District of Virginia would have like all the Arlington. Yeah, so I haven't done like a regional one, like what? Yeah, and then in CD Cal, where I've also done a couple, it's all Los Angeles is such a massive hub for them.
Yeah,
that asylum.
Well, I think you raised a good point, which is that you really have to have as a lawyer that's, even if you're not the lawyer that handled the asylum case, you have to have a really frank discussion with your client about what it means to speed it up, because it could be the facts have changed dramatically in the country that you're coming from, so that your case is not nearly as strong as it was when you filed it, or they've gotten a lot worse and maybe you're a lot more confident in the case now. But it is very much, and you also have to look at the statistics for what the approval rates are in the asylum office.
Yeah. I mean, I wonder,
consistent.
I wonder what the immigration bar would think about like a class action for mandatory asylum interviews within X days or something. I think there'd be like a lot of like, hey, what are you doing? I don't know. I mean, the good class action, there's a great class action brought about the EADs for people who filed affirmatively.
Yeah.
I could, but again, I think it has to be, at least the way I've done them, have just been individual people who've come and said, I really need an interview. I'm confident about my case and I can't sit here in limbo.
I have cases as well. I see this like in J1 hardship case. We do a lot of cases for J1 waivers, and an asylum is something that people will file. A lot of times people that qualify for a J1 hardship or persecution waiver might have a decent asylum case, and they'll be working the asylum case sort of in the background. The ideal, they have another plan, but it's there, and the fact that it's pending for a long time can be helpful in terms of the overall strategy of having something there that if everything fails on the other strategy, there's still the asylum claim that was we're not filing claims that we don't think have merit, but it is something that for a lot of people, it's not their primary strategy. And there really is, it really is probably not in their best interest to speed up processing on that. So I think you're right. And I think there probably would be a lot of lawyers out there who would say, this is not, what we would want is some kind of premium processing where there might be speed up. It's just sadly, asylums oftentimes are the most in the most precarious economic situations.
What would have been a great case would have been when they came out with the last in, first out, and they switched to Rude everybody.
Yeah.
That would have been to represent people who had filed when it was first in, first out, and to challenge that. That would have been a good case.
Yeah. Well, the other thing about those cases is the employment authorization. I guess that on there, there are side issues that come up in the asylum case as well. But I guess for people, sometimes I guess there are people that have family members that are outside the country. They need, where they do need to get these decisions moved, or people that we just learned that they're concerned that their case may be a lot less winnable in the future, like if there is a war going on, for example, and you're in a minority that's being persecuted by the invading army. If the war actually ends, then your case may be suddenly not very winnable if it takes 5 years to get to that point. There's a lot of factors that go into it, obviously, but I think it is an interesting area for mandamus for sure. So, any immigration law developments the last few days? Anybody wants to note?
I don't think so.
Okay. Well,
are they working in August in DC? Usually not, right? I think the only things that may be on the radar screen that could affect people would be, if the government were to shut down. If they don't, I know that there's rumblings about that happening this fall, and
there was some interesting change about Child Status Protection Act.
Yep.
A couple of days ago, and this question about they thanks to some really good advocacy by American Immigration Law Association and some individual AILA members like Cyrus Mehta. There have been some nice and Brent Renison, I think, also litigated on this issue. But there was this question about with the visa bulletin charts, whether you get any rights, whether you freeze your case, your I-140, if you're a beneficiary of the filing date chart versus the final action date chart. And USCIS finally came around to the humane way of looking at that issue several months ago and issued another policy memo this week that seems to about having, you have to demonstrate that you sought to acquire adjustment of status within a year, I guess, of the date being current. There are some questions now about retrogression, and I think this is going to potentially lead to new litigation but people who, if you retrogressed, does it reset the clock for a year in terms of sought to acquire or not on there? So that's an interesting question that that we're going to have to, hopefully USCIS will take a liberal view on that, but we will see.
Yeah, that to me is always like, the CSPA, here's another analogy and then we can end because I've obviously had way too much coffee. So that is like World War I. Every time I hear the story, I got to go back and read it again because I don't understand how it started, how we get there, who's on what side. The CSPA is so hard, but they have done good things to make sure that there's an earlier period than before to have children kind of frozen. Right, that's the best way. They freeze at some point.
I pay a lot of attention to that because Ari Sauer and I made a piece of software that is a CSPA advisor that asks every possible weird little scenario on there. And this week we have to make another change to incorporate this policy. But I like the CSPA because it is objective. I mean, there's like there's it's black and white as far as qualifications for it in a lot of cases, as opposed to giving audit discretion one way or the other to the agency. So black and white makes easier software.
Yeah.
So that's one of the reasons why I like it. But that's something I'm working on right now.
It's the one thing that's still kind of outstanding is it goes just part of the system where USCIS will take it one way and state will take it another though. And then that doesn't make a whole lot of sense. But they seem to, they agree on a lot of things, but I know on this dates for filing final agency action guidance that USCIS came out with, state had kind of slow walked whether they were going to do it. And, there's no sense for that. Like how would, there's no, it doesn't make any sense. Kid's either a kid or he's not. Like, both agencies have to get together and bring it out there.
Yeah. The only last thing I'll mention as far as things that happened in the news this week involves Afghans and extending their parole status for those that are in the United States. That was a question that USCIS issued a memo this week advising people. So if you're in that situation, it's mostly good news. And it also deals with like what's happening with people that have pending adjustment applications based on asylum it's worth, if you're dealing with Afghan clients or you are Afghan, it's worth reading that memo that came out this week. So that's the last thing I can think of newsworthy this week. Otherwise, that would be probably a good place to wrap it up. Chuck, I don't know if you're watching, but we're wishing you well in your recovery, and we will see everybody the next time.
All righty. Be good.
Bye-bye.